Hello everyone and welcome back to another video. It is Law by Race here again with you guys, and as you know, I prefer to really just read the written motions and give you some legal analysis. I don't really have the time and ability to live stream court proceedings or really go over video footage for the most part, and what I like to prefer to do is stick to written motions when I can, guys. So that's sort of the content that you can expect to find on this channel. Guys, we did have a motion here filed today on August the 6th, 2024 by Brian Steele on behalf of his client Jeffrey Williams, aka Young Thug, guys, and it's one that I want to get right into. Before I get into it, guys, I just want to mention that any amount of donations really helps. So you can find donation links, Buymeacoffee, Venmo, and CashApp, all in the description box below. Guys, if you cannot afford any sort of financial contribution, I understand completely. Just a like, a comment, subscribe, some engagement with the video also really helps. Okay, guys, so with that being said, let's head right into this motion and give you some legal analysis. Before we start, guys, I want to give a quick disclaimer that I am not a licensed attorney in the state of Georgia. I'm a licensed attorney in the state of Texas. If you have been recently charged with a crime in Nueces County, Texas, which is the Corpus Christi area, all the way up to San Patricio County, and the neighboring counties around around Nueces County, around Corpus Christi, please feel free to use the email link, guys, and you can get in contact with me if you are in need of representation. Again, I'm a practicing attorney in Corpus Christi, Texas, and you can find my contact link using the there's a way to find it, or you can leave a comment on the video. Whatever you need to do, you can find me, guys. Okay, so with all of that out of the way, let's go to the motion here, guys. So we can see here at the top right, this is the timestamp or the file stamp, Fulton County Superior Court. It is e-filed August 6th at 2:57 p.m. We see here in the stylus of the case in the Superior Court of Fulton County, state of Georgia. Then we see here in the preamble, or well, the stylus, State of Georgia v. Jeffrey Williams, defendant. Usually you would see like an et al. Here, but that's fine. Indictment number 22 SC, meaning 22 Superior Court, 2022 Superior Court 183572. And they go in chronological order, so that means there's a lot of indictments in the Superior Court of Fulton County, Georgia. And then we have Judge Whitaker, which is a little bit, odd. It's not how we do it here, but okay, I understand. Additional motion to disqualify lawyers Love and Hylton. Okay, guys, so here we start. Now, guys, a lot of you, if you are not in the United States, might not be familiar, but there's a lot of different ways that we call lawyers here in the great country of the United States. We call them lawyers, attorneys. Sometimes we call them solicitors, although that's pretty British or Indian. Can also hear to it referred to as barrister, although that's a pretty English term. For the most part, I prefer to go by attorney or counselor or counsel. I don't usually say lawyer, to be perfectly honest with you. All right, comes now, all bold. Mr. Jeffrey Williams, by and through undersigned counsel, Brian Steele is undersigned counsel, and hereby files this additional motion to disqualify lawyers Love and Hylton in the above referenced case. In support of this motion, Mr. Williams shows as follows. So a nice introduction there. Whenever you're writing as counsel on behalf of your client and you're referring to yourself, it is extremely common to go ahead and say the undersigned counsel and not refer to yourself by your own name. So that's just so you know, that's something that's pretty common. Okay, guys, paragraph number 1. Mr. Williams is innocent of all crimes in the above referenced indictment. Very strong language. Very, very strong language that's just going to hit right off the gate. I really like it. I think that's a strong form of legal writing. Number 2, this honorable court denied Mr. Williams' original motion to disqualify lawyers Love and Hylton on August 1st, 2024, based upon Mr. Williams' assertion that he intends to call lawyers Love and Hylton as witnesses at trial. 3, Mr. Williams respectfully requests this honorable court to consider the ethical violations made by lawyers Love and Hylton in support of this motion to disqualify. And then we see a case site here, see Ford Motor Company v. Young, which is a civil case, right? So you know that it's a civil case as opposed to a criminal case, or a civil suit as opposed to a criminal case. And why do you know that? Well, guys, in the state of Georgia, all criminal cases are going to be state of Georgia v. defendant. So is it a little bit odd to have a civil suit as your citation for a criminal case? It's a little bit, odd. It's not that it isn't persuasive, but it's just a little bit, it would be better if it were a criminal case. Okay, so let's have a look at this case, Ford Motor Co. v. Young. So this was a civil suit, and this is 322 Georgia Appellate 348, 745 Southeast 2nd, 299. Okay, so Ford Motor Co. v. Young. Summary, noting that standing was one of two jurisdictional issues in the case. Let me see where he's citing. So guys, I want y'all to know how to reference this. So this is what's called a string citation to multiple recorders. So this is in the appellate recorder, and it's also in the Southeast recorder, which is going to record appellate cases in all of the Southwest area. So, for example, in the state of Texas, we have the Southwest reporter, not the Southeast reporter. So he cites to the entire case and doesn't cite to the entire, or doesn't cite exactly where he's talking about. And let's have a look at this. Let's have a look at this case. Attorneys Alan Thomas and Paul F. Malik appeal an order revoking their admission to practice as trial counsel pro hoc vice in this product liability wrongful death case. Let's see, what was the outcome? Okay. We agree with Thomas and Malik that the issues of the revocation of their admissions pro hoc vice. Guys, so if you don't know what pro hoc vice means, pro hoc vice is when the court allows for temporary purposes, basically for an out-of-state attorney to practice on that case in another state. So, for example, if I were to work on a case in Oklahoma, I am not licensed in Oklahoma. I do not have an Oklahoma bar license, but I could work and be admitted to work on a case or cases in Oklahoma on a temporary basis, which is what pro hoc vice means. When you work in another state in which you are not admitted, you have to work under the supervision of local counsel. So you have to be affiliated with and work under the supervision of someone who is licensed in that jurisdiction. So I could not go and request on my own without an Oklahoma attorney to go practice in Oklahoma. So that's what pro hoc vice means. So they argue that their appeal is not moot. Let's see. All right, so here we have some discussions of why these attorneys were. So look, there was an order revoking attorneys Alan Thomas and Paul F. Malik, an order revoking their admission to practice as trial counsel, in this case pro hoc vice. So essentially, in this case, you had two attorneys that were out of state, that were practicing in Georgia pro hoc vice, and they committed some sort of ethical violation, and so their admittance to practice in Georgia was revoked. And so what is the ethical violation? So Mr. Williams respectfully requests this honorable court to consider the ethical violations made by lawyers Love and Hylton. So let's just make this easy. Ethic. All right, the trial court's order made specific findings that the attorneys had violated the Georgia rules of professional conduct. These findings may have continuing adverse collateral consequences for the attorneys' careers. See Division 1B Infra, which is lower. We thus conclude that because this order bears directly upon the attorney's interests, they are directly aggrieved by the decision. And then we can see a citation to the 10th Circuit. Attorney was directly aggrieved by disqualification order finding violation of professional conduct and had standing to appeal the order. All right, here we go. Although no Georgia court has addressed this precise issue, we have considered the issue of mootness in an attorney's appeal of a contempt conviction against him. We held that an attorney's appeal of contempt conviction was not moot, even though he had paid the fine imposed, quote, because of possible continuing adverse collateral consequences the attorney might suffer because of the conviction. So I want to see, this is a section on jurisdiction. I want to get into what the ethical violations here were. Okay, in the course of discovery, plaintiff's counsel served Ford with a request for production of documents, which is a discovery tool, asking for the production of any insurance policies that would be applicable in the case. According to the trial court, Ford, quote, failed to disclose the applicable insurance policies, did not object, and never supplemented its response to disclose any insurance policies. Rather, it responded that Ford had sufficient resources to satisfy any judgment that reasonably could be expected to be awarded as damages, which is not how you respond to a discovery request. The parties prepared a consolidated pretrial order. Section 4 of the pretrial order listed the individuals and entities with whom, let's see. All right, and then we have the plaintiffs included in that listing, any insurer of defendant Ford Motor Company, but counsel for Ford struck through that phrase. Ford explained that it, quote, objected to any reference to an alleged insurer of Ford. Ford has sufficient resources. Wow. I can't believe that someone actually wrote that. Rather than disclosing your insurance, we just have enough money to satisfy anything you could possibly award. That's wild. That's wild. This is a crazy case. During pretrial hearings, as the parties and the trial court reviewed the pretrial order, Ford's local counsel and Thomas objected to the plaintiff's request that the jury be qualified as to any insurer of Ford. Thomas specifically repeated the position that, quote, Ford Motor Company essentially is self-insured to a point that it would satisfy any judgment in this case, which is, why would you not just settle the case at that point if you're positive that it's going to, this is wild stuff. The court explained that the issue was not whether Ford had sufficient resources to pay a judgment, but the identity of Ford's insurers so that the jury could be qualified as to anyone who had a financial interest at stake, which made sense. When pressed further, Thomas said that he could not state that Ford would not make an insurance claim. He agreed to research the issue so that he could make a definitive statement on the record before the jury was qualified. Voir dire was scheduled for next week. According to the trial court, before voir dire began, Thomas again stated that there was no insurance, but the statement was not made on the record. After an entire day of voir dire, the following colloquy occurred. And then you can read this here. The next day, before the parties began to strike the jury, plaintiff's counsel informed the court that Thomas had notified plaintiff's counsel that Ford did have applicable insurance. The court stated, quote, Mr. Thomas stood here and you represented on the record on behalf of Ford, and I made it clear that if you then tried to use insurance or you wanted to invoke insurance, that it would be a mistrial. I've dismissed jurors. I've let people go. Local counsel for Ford explained, we kind of dug into this a little bit further. The court responded, well, we had pretrial hearings on June, I believe, 6th and the 7th, and then again maybe on the 8th. And at that time, the court instructed Ford to provide that information on the day we were to begin striking the jury and to be certain. And I told Mr. Thomas, along with the other attorneys, what the consequences would be, and Mr. Thomas assured the court that he would find out that answer. And he represented yesterday morning that he had inquired and he had found out that information. Local counsel clarified that Ford was self-insured up to $25 million, but 6 policies of excess coverage could be at play. Of course, they have reinsurance. It was later determined that significantly more policies could potentially cover the judgment. Thomas said that he had not intentionally misled the court. He explained that he learned by email that morning of the insurance and that he then promptly advised plaintiff's counsel and the court. Malik, the other Alabama attorney, explained that after the pretrial hearing, he and Thomas made a, quote, good faith inquiry with Ford, which responded that, quote, there was no insurance that it believed would be responsible to the concerns of this case and applicable to this case. Malik stated that he and Thomas did not know the information, had made efforts to obtain it, and had not made any knowing misrepresentation to the court. The court declined to hold Thomas in contempt at that time. Counsel for plaintiff raised the issue of Thomas's pro hoc vice admission. The court orally revoked both attorneys' admissions and later reduced its order to writing. It found that the continued pro hoc vice admissions, quote, may be detrimental to the prompt, fair, and efficient administration of justice, and that Malik and Thomas had violated Georgia Rules of Professional Conduct 3.3, candor toward the tribunal, and 3.4, fairness to opposing party and counsel. Because the trial court had not qualified the jury pool as to Ford's insurers, the court declared a mistrial and ordered as a sanction that Ford could not contest the plaintiff's assertion that it had failed to adequately warn consumers of the danger of a seatbelt during a rollover accident in a Ford Explorer. The plaintiffs and Ford settled and dismissed the case, and Thomas and Malik filed this appeal from the order revoking their pro hoc vice admissions. Right, so I know that some of you have probably already lost me, but why would Brian Steele, going to this case, go to a civil case looking at a 2013 civil case in which pro hoc vice admissions were revoked. Well, if I had to guess, when Brian Steele was doing his legal research, there was probably what's called a paucity, or a lack of directly on point cases. So he's getting a little bit creative and going out into civil land and finding something that's, analogous enough. And the basic idea is, okay, if we take this example of civil attorneys having their pro hoc vice admissions revoked because the court had found that they had violated their duties of candor and fairness, then look at these attorneys, the prosecutors, who are also attorneys, Love and Hylton, look at their ethical violations, and similar to how the other attorneys in the other case had their pro hoc vice admissions revoked, we think here, too, that these ethical violations require the prosecutors to be disqualified. Now, before I move on with Brian Steele's motion, I want to give you my current working thoughts before I go on, and that is the case that is cited here is not, it is somewhat persuasive, but it's not a silver bullet case. It's not exactly on point, and it's also a civil case. So yes, it does mention ethical violations. Yes, it is somewhat analogous, and yes, you had pro hoc vice, in that case, pro hoc vice admissions revoked for what the court considered to be ethical violations, especially with regards to the duty of candor. But is it exactly the same? No, it's not exactly on point. Number 4, the enormity of violations of candor with the court, candor with counsel, meaning the defense attorneys, and the denial of ethical prosecutors on this case are too much to permit lawyers Love and Hylton to continue as lawyers in this litigation. 5, the below is just a touch of the constant misconduct by lawyers Love and Hylton in this case. Romanet, if you don't know what that's called, it's called a Romanet. Romanet 1. Recently, lawyer Love filed a motion with this honorable court that undersigned counsel had a, quote, duty to provide work product. Lawyer Love knows that same is untrue, and the cases that she cited in said motion did not support the propositions of law that she asserted in the motion. And then he's citing to the motion that Love filed. See motion to compel defendants' compliance with reciprocal discovery obligations and to exclude any evidence intentionally withheld and not timely disclosed, filed on July 26, 2024. Guys, I know that there might only be one individual on this earth that might actually do what I'm about to say. But if you go back to my video in which I read through these motions and I provided my legal opinions, I said, that doesn't seem right. And now it's coming out into light. Yeah, it wasn't right. It wasn't right. There's no reciprocal. You are a criminal defendant. It is the state's burden. Do there exist reciprocal discovery obligations? Yes. But you do not have to turn over your impeachment evidence. And that's kind of a basic thing. Okay, this was the 4th time that lawyer Love raised this same frivolous issue, attempting to hide Georgia law from this court that she was explained at the 3 prior hearings on this exact same issue. See YouTube dated April 8, 2024 at 7:50. So here we have a timestamp, and then we have another timestamp. In paragraph 11 of the state's ex parte 7:50:40 through, right, so these are timestamps, but this timestamp doesn't look quite accurate. That doesn't look right. I think that's probably backwards, right? This timestamp should be ahead of this one. Romanet 2. In paragraph 11 of the state's ex parte motion for order to compel testimony necessary to the public interest, there is zero truth to the assertion that any defense meeting occurred with Mr. Copeland to impact Mr. Copeland's decision to invoke the Fifth Amendment or any other matter. No defense lawyer on this trial had any connection or involvement with Mr. Copeland on or around June 6, 2024. This is a knowing misstatement by lawyer Love. So again, he has to, if you're going to swing, let me put this in layman's terms. If you're going to swing for the fences and you're going to try and get prosecutors disqualified, you got to swing hard. So, he's swinging hard. He's stating not only, it is one thing for an attorney. An attorney is just an individual like anybody else. We have a lot more education than most people, but we're not. I'm certainly not perfect, and attorneys are not perfect, and we make a lot of mistakes, tons of mistakes. I think that's obvious. But there is a difference when you make an unknowing error, harmless error, or you weren't aware of something, especially if you're practicing, you're a newer attorney like myself, or you're practicing in an area that you are not super familiar with, or you are allowed to make mistakes, guys. You're not going to get disbarred because you make some mistakes. The question is whether you are making those mistakes intentionally and with the intent to defraud, or the intent of deceiving the tribunal, or deceiving the tribunal, or not only deceiving the tribunal, but not being fully candid with the tribunal, which is what your ongoing obligation is. So if you're going to swing to disqualify lead prosecutors, you got to swing hard, and that's what we see in this motion. Prior to opening statements, the former court ordered all parties to share with each other any demonstrative aids that they would seek to display to the jury during opening statements that were to begin on Monday, November 27, 2023, so that objections could be made prior to presentation of the opening statement. So let's have a watch of this.
Or just accordingly based on that. I don't do it on a witness-by-witness basis. And you can also exempt the people out that you believe,
sure,
that are not subject to the rule, or you'd like me to exempt on a case-by-case basis. So
I understand that, but I don't want to violate a rule. So with regards to openings, under law, they're excluded because they're not evidence, but it's the evidence that they can watch. But if you say, don't let your witnesses watch statements, I'm going to tell them that.
Usually before we begin opening statements, I'll ask about the rule, invoke the rule.
Okay. Yeah. All right. And then the second thing is, can we agree? I'm asking the court because, as the court, as the power, can we exchange, if it's okay with the colleagues too, any type of exhibit that we plan on using in opening, so we don't have to delay the jury? Because
yes, that would be wonderful, because then we won't have objections and other things that would be otherwise disruptive. And I think that the smoother your presentation is, the better off you'll be. But like I said, there shouldn't be too many, at this point, there shouldn't be too many surprises with anything. But I would say that would be the best thing to do.
Okay.
Well, so that we don't draw any objections. So I think that would be proper. Ms. Love, do you think you all can do that?
Yes, we will submit any pictures or any photographs or anything of the like that we would like to show.
I think you all can. I think if you all did that informally, and then if you needed my assistance.
Okay, so as we just watched that video clip, on Friday, November 24, 2023, 4:58 p.m., Lawyer Love shared her supposed demonstrative aid. During opening statements at trial, Lawyer Love showed a completely different demonstrative aid in violation of the prior court's order. And then he's just time-stamping all throughout this. So let me see here. Prior to opening statements, the former court ordered all parties to share with each other any demonstrative aids that they would seek to display to the jury during opening statements that were to begin on Monday, November 27th, 2023, so that objections could be made prior to presentation of the opening statement. And then we check the citation here. We watch the video clip. On Friday, November 24th, 2023, at 4:58 p.m., Lawyer Love shared her supposed demonstrative aid. During opening statements at trial, Lawyer Love showed a completely different demonstrative aid in violation of the prior court's order. And then here we have a timestamp here. There have been no consequences for Lawyer Love's intentional, unethical, and continued misconduct, semicolon. Romanet 4. During the same opening statement, Lawyer Love defied another pretrial former court order without first obtaining permission from the now recused court by introducing to the jury that undersigned counsel, meaning Brian Steele, had represented another person charged in this case, And then see order dated November 17th, 2023, granting Mr. Williams motion in limine number 23 attached here too. Specifically, in her PowerPoint, lawyer Love showed the jury that undersigned counsel, again Brian Steele, represented co-indictee Blaylock. See YouTube dated November 27, 2023. We have a timestamp here. Romanet 5. Lawyer Love accused undersigned counsel of knowingly and intelligently misrepresenting to the jury that Mr. Bean was taken to Grady Hospital by police from the scene of his arrest on September 11, 2013. At a bench conference, lawyer Love falsely stated that she had evidence, quote, on her table to prove, and here we have in brackets, the undersigned counsel fabricated evidence as to Mr. Bean never went to Grady Hospital on September 11, 2013. And then here we have citations to the video link. Lawyer Love's allegations against undersigned counsel to the prior court were proven beyond any doubt to be totally knowingly false. Again, we have plenty of video timestamps here, which guys, I'm just going to be honest with you, I'm not going to go through all of them. Romanet 6. Over Mr. Williams' objection, when the state was attempting to introduce a January 16, 2015 social media posting from co-indictee Garlington's account during the testimony of Detective Gaither, lawyer Love told the prior court that only Mr. Williams' voice could be heard on this video/audio except for one other voice saying, quote, yeah, in the background. Undersigned counsel told the prior court that lawyer Love was incorrect and that several persons' voices were audible on this social media posting. Lawyer Love falsely accused undersigned counsel of misrepresenting facts to the prior court. Of course, lawyer Love was proven to be the person who was untruthful and was again falsely accusing undersigned counsel of wrongdoing. This pattern of prosecutorial misconduct illustrates the enormity of unethical conduct of lawyer Love and the state of Georgia in this case. And then here we see another timestamp and Microsoft Word doing its magic. Romanet 7. On Thursday, June 6, 2024, as well as Friday, June 7, 24, lawyer Love falsely accused undersigned counsel of purposefully extracting and tampering with jail recordings of Mr. Copeland. Again, this was another knowing, malicious, false allegation by lawyer Love as she continues her unethical conduct. And then, guys, I have drafted a lot of motions in my time as an attorney, and I don't know why when you start putting in URLs that Microsoft Word starts doing this crazy stuff. But I'm glad to see that somebody else had this happen to him, and it's not just me, because that has happened to me before. These crazy spacing. I don't know why you put in a URL and Microsoft Word goes crazy. But if anybody has any information on how I can draft a clean motion where that doesn't happen, please do let me know. And Romanet 8. On Monday, June 10th, 2024, lawyer Hylton, lawyer Love, and the now recused trial court attempted to hide Brady evidence, meaning exculpatory evidence, from Mr. Williams and the other accused that was obtained during the unlawful ex parte meeting with sworn witness Copeland and his counsel. Specifically, Mr. Copeland made statements that everything he says is a lie, that he committed all of the crimes in the indictment and the like. These statements are impeachment of Mr. Copeland and are squarely within the concept of Brady v. Maryland, Volume 373 U.S. 83. And then we have 3 citations. So Brady v. Maryland, let me give you all an idea of, I'm going to give you the synopsis of Brady. All right, guys, Brady v. Maryland, and then let me go to the summary. This is the case, Brady v. Maryland, 1963 case, and you can see all the citations here. So, here's the overview. A judgment granting petitioner a new murder trial that was restricted to the issue of punishment was affirmed. After petitioner was convicted of murder and sentenced to death, he learned that the state withheld a statement in which another individual admitted the actual homicide. The court held that suppression of evidence favorable to an accused upon request violated the due process clause of the 14th Amendment to the United States Constitution, where the evidence was material to guilt or punishment, regardless of the state's good or bad faith. The suppression of evidence violated petitioner's due process rights and required a retrial on the sentence. The court held, however, that it could not assume that if the suppressed evidence had been used at the first trial, the ruling that the statement was inadmissible as to guilt might have been disregarded by the jury. In Maryland, it was the trial court, not the jury, which ruled on the admissibility of evidence relating to guilt. The appeals court's statement that nothing in the suppressed confession could have reduced petitioner's offense below a first-degree murder was a ruling on the admissibility of the confession as to the issue of innocence or guilt. And then outcome, the judgment granting petitioner a new trial restricted to the issue of punishment was affirmed, where the suppression of evidence by the state violated petitioner's due right to process of law and required a retrial on the sentence. And then here we have Brady material, Brady claims. The suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. So guys, this is the landmark case when people talk about Brady material. What is Brady material? Brady material is evidence which is material either to guilt or to punishment. And the state, upon request by the defense under Brady v. Maryland, has an obligation to turn that over. So Brady material is typically referred to as Brady materials where you have to turn over exculpatory evidence, but it's evidence material to guilt or to punishment, technically. Okay? So these statements are impeachment of Mr. Copeland and are squarely within the concept of Brady v. Maryland. So what is the concept of Brady v. Maryland? Right? The concept of Brady v. Maryland is that the suppression of the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment. So if it violates due process, you get another trial. So what is the violation of due process here? So Mr. Copeland made statements. What are the statements? Mr. Copeland says everything he says is a lie, that he committed all of the crimes in the indictment, and other statements. Why are those statements material? Because it is evidence either to the guilt or to the punishment of Young Thug and the co-defendants. It is material either to the guilt or innocence, or to the punishment of the co-defendants, because remember, the state has the burden of proving guilt beyond a reasonable doubt. And so if you have this other guy, namely Mr. Copeland, up there claiming all the crimes and saying that he did everything and he's a known liar, that is something that the jury needs to know about. That is something that could reasonably bring doubt, a reasonable doubt into a juror's mind. A juror could think to himself, you know, maybe Kenneth Copeland did all of it. And so, ergo, acquit the accused. Or the judge, let's say that the accused are convicted of RICO, and then at the sentencing phase, in terms of punishment, the judge looks at all the factors in terms of creating a sentence, an appropriate sentence, punishment, and the judge looks back at this Kenneth Copeland statement where he's rambling on about how he did all of it. That could also be material to punishment. And so you've got this guy, Kenneth Copeland, who's basically claiming that he did everything and he's a known liar and he doesn't really want to get up there and testify, presumably because he's scared for his life if he did. No, regardless of that, it is evidence that is material either to guilt or to punishment, and it needs to be turned over. So here we go. I'm going to reread this one more time. On Monday, June 10, 2024, lawyer Hylton, lawyer Love, and the now recused trial judge attempted to hide Brady evidence from Mr. Williams and the other accused with an S, that was obtained during the unlawful ex parte meeting with sworn witness Copeland. So basically, why is it evidence? Well, you and I just talking is not evidence, but sworn testimony is evidence. And so you've got this guy Copeland, he's a sworn-in witness, and he's rambling. And so even you're rambling, when you're under oath, you're a sworn witness, that testimony is in fact evidence. Okay? It's testimonial evidence. So that's the argument here, and I totally understand it. And I'll be honest with you, I do think that this is a good argument. Moreover, lawyers Hylton and Love, with the assistance of the now recused judge, told Mr. Copeland that he would not get in trouble if he had lied under oath unless he told a, quote, bold-faced whopper, end quote, of a lie, that he could not be prosecuted based on some erroneous theory that the statute of limitations has run. It's really had ran. And Mr. Copeland would have to remain in custody until all 28 co-indictees' cases resolve. This is all unethical conduct in order to intimidate/coerce Mr. Copeland to testify at trial. Number 6, the above does not truly encapsulate the horror of working with lawyer Love and lawyer Hylton, not to be able to trust the prosecution to provide the simplest and most basic fundamental fairness, such as honesty to the tribunal and honesty to all in the courtroom, must mandate that both lawyers Love and Hylton be disqualified from this case. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, ask this honorable court to grant the above requested relief. Okay? So, I think before in this video, I want to give you my thoughts on sort of what the strongest argument here, and it's got to be the suppression of Brady evidence. The court attempted to hide Brady evidence from Mr. Williams. So again, you've got this Brady evidence, right? And Brady evidence, we know, is evidence favorable to an accused. The suppression by the prosecution of evidence favorable to an accused upon request. So it's evidence favorable to an accused, otherwise known as exculpatory evidence. And you have this guy, Kenneth Copeland, he's sworn in and he's making statements. In other words, he's testifying under oath, and he's testifying to something that could reasonably bring doubt in a juror's mind. That is exculpatory evidence by definition. Regardless of how crazy Kenneth Copeland is, irrespective of whether any of what he says is true or not. In fact, even if he's lying, in fact, that's really a stronger argument for the defense, because he's the state's reluctant star witness after all. So this ex parte meeting where Kenneth Copeland is testifying, and he says that he committed all of the crimes in the indictment. Now, I know how he actually said that. He said it in a farcical way. It doesn't matter. It's testimony, and it goes to the credibility of that witness, and it is exculpatory evidence. And I totally agree with this argument. Now, guys, I will tell you that I have a strong bias towards the defense here. I myself am a criminal defense attorney, and I just tend to prefer the defense, but this is Brady evidence. Kenneth Copeland's testimony is exculpatory evidence. And from what I have seen, I would tend to agree with Brian Steele here that these two prosecutors have intentionally suppressed exculpatory evidence, and that has violated these defendants' due process rights, and there should be a mistrial with prejudice for prosecutorial misconduct. That's just, that's my opinion. And I think that this Brady argument here, specifically with the sworn testimony, is strong evidence of that. And when it comes to these two prosecutors, it's wild. It's just wild to me. But it is what it is. But I'm glad that there's a light being shed on it. So, guys, my name is Reese. I am an attorney practicing here in Corpus Christi, Texas. If you have been accused of a crime in Nueces County or the Coastal Bend area, please feel free to send me an email and get in contact with me. I can help defend your case, guys. So let me know. Other than that, guys, if you want to support this content and this legal analysis, please keep in mind that my making these videos does take some time away from other things I could be doing. So any amount of financial support using the donation links is greatly appreciated. Thank you, guys. Please make sure to like, comment, and subscribe, and use the donation links in the description box below. And we'll be back with more motion analysis when we have it. Bye-bye.